only two requests. I'm not arguing here. Two requests. On Prem Kumar Jain, I may be permitted to file a 2-page note.
Sure.
But how it's not a good law, and your lordship.
You have the note right now?
No, I'll file it by tomorrow. No. Second, I have already filed an application seeking reference. I have already argued the points. So for that also I'll file.
No, but we didn't hear any argument on a reference of that.
What your lordship will do with it is your lordship prerogative there. You already dealt with NDMC. For that reason, it should be referred to now 9 judges or maybe 11. Malas, with respect, this will be hugely dilatory. Your lordship has spent all the time. Today, Malas, we have gone into the constitution bench, we've gone into everything.
Lord, it can be anything but dilatory, my lord. We are sitting with the capital of the nation, my lord, and therefore, whether it is done today or tomorrow, my lord, that hardly makes any difference. My learned friend may be in a tremendous hurry to do certain things, my lord, but we are more on the future course of action, my lord. We may not be remembered in history for having handed over, my lord, capital to a complete anarchy.
I don't see
that's, my lord, my argument, and I have made those submissions. I'll just, Lord, put it 2-page note.
In his entire 90 and 54 pages, total of 140-50 pages, no reasons given for reference. Not asked. In his entire submission. Well, this is with respect. We can't repeat this capital like a mantra every time. Of course, it's the capital. And it's a capital with a legislature with representative democracy. Their argument is the merit, nothing to do with the reference to 7 judges. Today, your lordships, having dealt with the entire 2018, so many paras, are suddenly at the end of my rejoinder, Manu asked for reference. That would be very unprecedented for a constitution.
I stated that I have covered the issues in my submissions. If your lordship permits, I'll place a 2-page.
May I start?
Yeah.
But can I place a 2-page note on that? Well, that's all.
I am objecting. This will go on and endlessly. It will be made a ground subsequently for a 9-judge bench reference.
No difficulty that you can certainly give your note, because that's a question of law about.
Understood. I leave it at that. It's ultimately my lord's entire prerogative. Your lordships may only record that I reiterated, your lordships have not considered. That's all. It should not be, my lord, argued that it was argued and rejected. That's all.
It should not be an ambush procedure, Manas. And your lordship.
No, I'm saying something factual.
This issue can.
Yes, it's not. It's a reasonable request that your lordship may record.
Yes.
Say that we are not going in.
Now, Manas.
Yes.
Allocations of civil service in Agmat cadre is done by the joint cadre authority and not by the Ministry of Home Affairs. Is it continuation of point 3? So I'm sorry, I have to read it like this. The union is arguing that control over allocation to the constituent part of the joint cadre is done by the Ministry of Home Affairs, relying on a resolution of the joint cadre authority in April 89, which Chief Justice just asked me to show. I'll show in a minute. This is that resolution of 1989. I have shown you notifications, etc. of 95. A mere perusal of the same shows that the Ministry of Home Affairs is merely acting transitionally as a delegate of the Joint Cadre Authority. It says, till such time as the Joint Cadre Authority creates a committee. And it is no longer the cadre controlling authority. More importantly, this is the second reason. The 89 resolution is before 239AA came into being. Post 239AA is reflected in the 25,495, which my lord just now saw in a minute ago. It syncs completely, it fits in harmoniously, where Delhi is represented in the authority by its chief secretary, similar to the full-fledged states of Arunachal Pradesh, etc., etc. Then this para 12 is the addition, which is why I have to file this. Very important. Very, very important. That a civil services board exists in the NCT of Delhi to advise on transfers and postings within NCT Delhi. This is vital. The existence of a civil services board in Delhi, in fact, shows that Delhi has been treated at par with the state and not a union territory which is not going to be enjoying any benefit of a state. The IAS Cadre Amendment Rules of 2014, I'm sorry. Now, you also remember he cited TSR Subramanian. Post the judgment of Subramanian, there is an amendment to Rule 7. This is vital. It is in the bookmark, but I'll read it from here. It's quoted. Actually, I'm sorry. The entire picture is not there. So may I take a lordships to these two documents, not read from here, because I'm not quoting the whole thing. So would my lords first see the resolution Mr. Mehta relied upon in CV 4, page 138, and then this Rule 7 amendment. Convenience, volume 4, the relevant page is 138.
Convenience, there were 3 convenience volumes.
No, there was it's called a final compilation, which will should call 4 actually. Functions to remain within, please mark the date, 1989, and a resolution, not a statutory notification. Note these 2 points. It's 1989 and a resolution. Functions to remain with the MHA UT division. Transfer posting of cadre officers from one segment to another. However, for this purpose, Joint Cadre Authority will frame proper guidelines, keeping the overall interest of the service officers as well as the state constituent units in view. Till the new guidelines are framed by the Joint Cadre Authority, transfer posting from one segment to another will be guided by the guidelines as existing on date. This is 89, then comes 92, your lordships 239 AA, then comes the statutory notification in 95. And the language of this itself is till such time.
Yes.
Now, the second item is amendment to Rule 7, which is at same compilation, bookmark 5 at page 131.
So this was October 1989.
Correct.
Then what is the date of the joint cadre rules which you showed us?
That is
Joint cadre rules.
the rule or the notification?
The rules.
Oh no, rules.
The notification.
Just so that we can put it here.
Notification, statutory notification.
And the joint cadre rules of page 3949, what is the date of those?
1972. Correct.
That is 1972.
That is a general joint cadre rule, pre-existing rules.
Cadre rules.
There before that. Now, my lords will kindly come to the amendment to Rule 7 in the context of Subramaniam also, which was cited at 131 of the same 4th compilation. This is important, the source of power and energy. In exercise of the powers, so again, same statutory source. In exercise of the powers conferred by 3.1 of the All India Services Act, which my lord has read with me, the central government, in consultation with the governments of the states concerned, hereby makes the following rules further to amend the rules, the cadre rules of 1954, which my lord just asked me.
Yes.
These rules may be called the IAS cadre amendment rules of 2014. If your lordship will come to 2A, just under this, 2 lines below this. In the administrative service cadre rules of 54, for Rule 7, the following shall be substituted. All appointments of cadre officers shall be made on the recommendation of the Civil Services Board as specified in the schedule annexed to these rules. All appointments to cadre posts referred to in Sub-Rule 1 shall be made in the case of a state cadre by the state government. In the case of a joint cadre by the state government concerned. Then kindly see how they understand the word state. Kindly go on. Just like the earlier rules, but state is the only word used. UT is not used, but they understand it to include UT. Then may I with your lordship permission skip 3, 4, 5 and 7A. May I skip that? Kindly come below 7A, just the next page. For the schedule, the following schedule shall be substituted. Schedule. Composition of Civil Services Board. Every state government shall constitute a Civil Services Board which shall consist of Chief Secretary, Chairman, Senior Most Additional Chief Secretary, Board Revenue, Financial Commissioner, etc. rank, Member, Principal Secretary, Department of Personnel, Member Secretary. The Civil Services Board shall make recommendation for all appointment of cadre officers. This is the Civil Services Board functioning in Delhi. Where does it come from for a union territory if you read the state technically? The Civil Services Board shall examine the cases of officers who are proposed to be transferred before completion of minimum period. They have always understood the UT to be included in all these rules, even though the word state is mentioned. They are having a Civil Services Board. It's a different matter that he exercises the power and doesn't allow me to exercise. But the Civil Services Board is here.
Just technically, I read this yesterday.
That's all right. And I'm giving you
I
a
read-
submission.
It's not as if this was.
I'm not saying you suppressed it. I'm saying
Yes,
I'm giving an
I read
interpretation.
it.
Of course, the Civil Services Board, like everything else, is an advisory body. It makes suggestions. The government can always accept. This covers my para 11.
LG.
Yeah.
That was my submission.
No, that obviously advises the LG or the NCT government, but it will be a later issue. Now, I have done with this point, and you know, may come back to yesterday's rejoinder. So these are the 2 points related to para 3. I'm sorry, Manu, the Lordship may make a mark in para 3 of the yesterday's submission that they should be read with 11 and 12, which my Lord has just read. I now come to my yesterday's rejoinder note to para 4.
Yes.
Now your Lordship asked me that question on 309. Yesterday I said, I answered it, but I said I will be coming to it later in the note.
Yesterday's note.
Yesterday's note, para 4.
Scope of entry.
Correct. Scope of entry 41, list 2 is wider than the scope of the proviso to Article 309, and any executive action under 309 does not limit the power of the legislature to make laws under entry 41, list 2. That's the head proposition. Before I read that, may I itemize the points here? It will be easier than reading, then I'll read only one part. The points which I said yesterday need to be itemized now. A. I'm repeating, but I'm itemizing it under this section. The Constitution. 309 starts with subject to the whole Constitution. And necessarily, our special part dealing with 239 AA, etc., is part of that Constitution. And 309 is subject to that, to the entire Constitution. It says subject to this Constitution.
239 also says subject.
No, it says in only one clause. Not in
A.
I checked. 3A. Only in 3A. That's the point. My Lord is right.
Yeah. These points you have enumerated here, or you're now
Well,
just.
it is here, but maybe not with that particularity. That's why I'm asking Lordship to just ABC only 3 points.
All right, just tell us.
It's not with this form. A, subject to the Constitution, just a general point, I'm not relying only on
Subject.
is the opening word of 309. Subject to the provisions of this Constitution, comma, acts of the appropriate legislature, etc. So it's even acts, subject to. Second, B. Prem Kumar Jain was a direct case in the same part, 14, same chapter 1. 3 sections apart in 312.
Yes.
For 312, 4 learned judges of this court, which has stood the test of time, held that UT is covered and subsumed. In that case, the UT of Himachal and Delhi were held to form a joint cadre reversing the High Court, which said, because they are UTs, they are not covered under the word state. So, the C point is that it has been already decided by our lordships that UT is covered, albeit in a case arising under 312. D. Absent any special provision of this chapter or this part, your lordship will never read 312 to include UTs and 309 not to include UTs. As simple as that. As legislative power, it would be a very startling result unless your lordship were forced by some language to do it.
312 to
D is, I've dealt with C, which is for 312. Absent specific exclusionary language in the Constitution in this chapter, your lordship will never read UTs to be subsumed under 312 as Jain holds, and UTs not to apply to 309 as my learned friend, the solicitor, argues. Imagine the startling consequences of that kind of interpretation. They are the 4 points which are not put in this form, so your lordship is kind enough to do it.